So hello everyone and welcome to day 12 of our marine cargo insurance course. So today we are going to talk about a very important concept called subrogation and how it works in practice when your insurer tries to recover money from someone else. It's all about who ultimately pays for a loss when a third party is at fault. By the end of the session, you'll be clearly understanding how your insurance company can seek recovery and why your cooperation is absolutely vital in this process. So let's quickly recap the principle of the subrogation that we first touched upon on the day 2. In simple terms, it means that after your insurance company pays you for a loss that is covered by your policy, they then step into your shoes. This gives them the same legal rights that you would have had to go after any other party who was actually responsible for causing that loss. The purpose of this is twofold. First, it prevents you, the insured, from making a profit from the loss. You can't get paid twice for the same damage, once by the insurer and once by the responsible party. Second, and very importantly, it ensures that the party who was truly at fault for the loss ultimately bears the cost, not your insurance company indefinitely. So, once the insurer has paid your claim, how do they actually exercise this right of recovery? First, there is investigation. The insurance company, often working with their marine surveyor or legal team, will thoroughly investigate the incident. Their goal is to identify exactly who was the negligent party, meaning who was at fault for causing the loss. Second, notification. Once they have identified the responsible party, the insurer will formally notify them. This is a written communication stating their intention to recover the money they paid out for your claim. Third, negotiation or the litigation. The insurer will then try to negotiate a settlement with that responsible third party or with their own insurance company. They will try to reach an agreement for repayment. If they can't agree and negotiation fail, the insurer may decide to take legal action, meaning they might sue the responsible party in the court. Fourth, that is the recovery. If all goes well and their efforts are successful, the insurer will recover the part or all of the claim amount they paid to you. This helps them recoup their losses. Who are the common third parties that insurers might pursue for recovery actions? Most often, it's the carriers themselves, the shipping lines, the airlines, or the trucking companies. This could be because of their negligence or the breach of their contract with you, or if the loss exceeded their limited liability. It could be the port authorities or the terminal operators if your cargo was damaged while it was under their care at the port or the terminal. They might be held accountable. Stevedores are the workers who load and unload the cargo from the vessels. If damage occurs during these operations due to the negligence, they could be on the target for the recovery. Sometimes it might even be the manufacturer or the suppliers of the goods, especially if the loss was caused by inherently defective packaging or a faulty product itself. And finally, in case of the maritime accidents, it could be the other vessels involved in a collision that cause damage to your cargo. Now let's talk about your role, the insured's role in subrogation efforts. Your cooperation is absolutely crucial for the insurer to succeed in recovering funds. Cooperation is paramount. You must fully cooperate with your insurance company as they try to recover the money from the responsible party. Think of yourself as a team working towards the same goal. This means providing documentation. You need to give them all the relevant documents and information you have related to the loss and the third party who was at fault. You also need to assist with witness statements. If your employees or anyone who who anyone else witnessed the incident help the insurers get their statements. And this is very important point. No barrier of the rights. You must not sign any document that release the carrier and any other third party from their responsibility or that waive your right to claim against them without first getting your insurance company's approval. If you sign such a document, you could seriously jeopardize your insurer's ability to recover their money, and this could even lead to your own claim being denied by them. So always consult your insurers before signing anything that might affect liability. Finally, let's briefly touch a waiver of subrogation clauses. In certain business contracts, you might come across a clause where parties agree to a waiver of the subrogation. What this means is that your insurer, even after paying your claim, cannot then go after a specific named party to recover their money. For example, if you have a long standing relationship with a particular logistic contractor, you might agree to waive subrogation against them. However, such waivers are not automatic. They usually require a specific endorsement or an official addition to your insurance policy, and you might have to pay an additional premium for it. So it's important to understand when these waivers are necessary in your contracts and what the implications as are for your insurance coverages and costs. So that concludes our session on the rights of recovery and subrogation. Its fundamental principle that ensures fairness in the insurance ecosystem. Now I'd love to hear your thoughts. Based on everything we have discussed today, why do you think it is so absolutely crucial for the insured to not sign any away their rights against a carrier or any other third party without first consulting their insurer? What are the potential consequences? Please share your insights in the comments below. Thank you so much.